And ma'am, you can also unmute. So though it's a late night, but the sessions in the evening are being picked up. Yeah, Vikram.
Yeah, good evening, one and all. Good evening, ma'am. It's a great privilege to have Senior Advocate SUSHEELA Madam with us. To say about Madam, it's an honor, and one person whom any person could approach as a mediator, as a senior advocate. You ask her any small doubt, Madam has so much of patience, and she would simplify it, and she always extends that smiling face, which would create that warmth and affection. And as a mediator also today, you would have seen, I'm sure Mr. Vikas has experienced this. The moment we updated this on the LinkedIn, certain comments were poured regarding Madam and her great efficiency. So with that, before we extend a warm welcome to ma'am, I would like to mention about her book. Ma'am has authored, she's been on regular basis. She writes articles for various journals, but more particularly, I wanted to highlight about the Hindu law book, which Madam has written, Hindu Marriage Act. It's a very, very user-friendly, reader-friendly book, which everybody should be making use of. So with that note, ma'am, once again, a very warm welcome on my personal behalf and on behalf of Beyond Law CLC and Mr. Vikas Chetrat. Over to you, ma'am. Thank you so much.
Thank you, Mr. Vikas. Thank you, Mr. Vikram. Greetings to one and all. It's a great privilege to be associated with Beyond Law CLC and equally so with Trivikram Associates. We are doing yeoman service. This is how, after reaching a certain point in life, we start doing something for our fraternity and also for the litigants. I really appreciate this. This is a sincere appreciation from my end. Now, today's topic is effective use of ADR in divorce proceedings. I'm given 45 minutes time. How I have structured it: first half of the session, I'll be taking you through the provisions of law as far as divorce is concerned. I would like to confine myself only to Hindu Marriage Act and divorce proceedings under the Hindu Marriage Act in this session, because for paucity of time, I do not want to get into the provisions of law as far as divorce is concerned in respect of Christians or Mohammedans, etc. So I will confine myself only to Hindu Marriage Act. Second is, as far as ADR is concerned, I would like to confine myself to mediation, conciliation, to some extent on negotiation and neutral evaluation also. This is how I have structured this. Time has come for us now to integrate ADR into our justice delivery system. As a litigant approaching the court for divorce or opposing the petition for divorce, what does he or she want? What for our courts meant? This question may arise in the mindset of any individual who approaches a court of law. Marriage may be solemnized anywhere, but as far as divorce is concerned, one has to approach court only. We can't avoid that. Everyone has to go through the court proceedings in order to get a decree of divorce. This cannot be avoided at all. Now, we know there are three tiers. First is a family court, and then there is a high court, and then there is a Supreme Court. In the best possible scenario, if we say in each court, we have 3 years of time, assuming for a while. 3 years, 3 years, 3 years means 9 years we spent. Worst scenario is 5 plus 5 plus 5. That is 15 years will happen. Assuming for a while, neither we go to the best scenario.
Ma'am, for a minute, I will just request you, we will take a session within 2 minutes because there was some issue with the YouTube. We will start it afresh. Use in a minute. because we are going live on the Facebook, but there was some issue with the YouTube. So you otherwise at your place?
Yes, yes.
You have that book also? We can show the book otherwise by the end of the session. Your HMA book?
Yes, yes.
Okay, sir. I have also got it. So the substantial question of law on which publisher you are doing?
Same your publications, your publishers.
Just a minute, ma'am.
No issue.
Yeah, good evening, friends. There was some technical glitch, and therefore we are starting the session again. And amongst us, we have SUSHEELA, a senior advocate, who is not only known as a lawyer as such, but an author, coupled with her blogs. And people see her as a good resource person. And once we say of the author, I will just share the book which she has written and which is being well received. You can all see this. And friends, though, at least I have read this book. It's quite a fascinating and stimulating for the mind of a lawyer as such. Without taking much time, since we are already running behind the schedule, I request SUSHEELA ma'am to take things forward on behalf of Beyond Law CLC and Vikram and Associates. Over to you, ma'am.
Thank you, Mr. Vikas. I'm extremely, it's a wonderful opportunity given to me to share some of my views with those who would like to have some inputs from others. I was appreciating Mr. Vikas and Trivikram because it's a yeoman service they are doing to fraternity and also to litigants at large. I wish them all the best. Let them continue this journey as long as they live. Today's of ADR in divorce proceedings. How I have structured this. First half of my session, I would like to take you through the provisions related to divorce proceedings, and I would like to confine myself only to Hindu Marriage Act because of the paucity of time. I do not want to get into the provisions related to divorce as far as other communities are concerned. And when it comes to ADR, I would like to restrict myself only to mediation, conciliation, negotiation, and to some extent on neutral evaluation also. Now you see our court system is very old. It's more than 100 years old. Litigants will have immense faith in the court system. They may not have the same faith in the mediator or somebody else because this is a new area. A marriage may be solemnized anywhere, but as far as divorce is concerned, one has to approach the court of law only. Divorce proceedings cannot take place anywhere else. So we have to depend on court. Now the question is, Can court alone handle family court matters, or has time come for us to integrate this ADR mechanism into delivery of justice, system of delivery of justice to a common man as far as these family court matters are concerned? This is one question we need to consider. What will happen if the entire burden is taken by the court? What will happen if there is a fine synergy or there is an integration of ADR mechanisms and also the control over the entire mechanism in a way by the courts? How do we go about it is one question that we need to understand. Supposing a person wants to go to a court, he wants to take divorce. The other person will be there who will be there to oppose these divorce proceedings. By and large, we know that there are three tiers. First is a family court, then high court, then the Supreme Court. The best scenario is 3 plus 3 plus 3 years. Worst scenario is 5 plus 5 plus 5 years, 15 years. So let us not go to the best scenario or the worst scenario. Let us go to the most likely scenario as far as time is concerned. So 15 plus 9 is 24, divided by 2 is 12 years. Approximately, it may take 12 years for an individual to get the ultimate decision from the highest court of our country. But what would that decision be? There is still an uncertainty. You can't be sure that you will be getting a decree of divorce. Or you may get a decree of divorce also, notwithstanding opposition by the other side. This is one thing that we need to understand. As far as this Hindu Marriage Act is concerned, we have 21B, section 21, capital B, where it provides a special provision with regard to trial and disposal of the matters covered under the Hindu Marriage Act. When we look at 21B, it clearly says the trial has to be concluded within 6 months. And as far as appeals are concerned, it says every appeal has to be disposed of within 3 months. But I am 36-year-old in profession. I am 60-year-old lady. Many of you are there who have richer experience than me and expertise than me. We all know that this is not happening within 6 months, and within appeals are not getting disposed within 3 months. Within 6 months, it's not happening. And in addition to this, various states have case flow management rules also. In Karnataka, we have Karnataka Case Flow Management Rules, 2005. There also we have a specific provision. There are different tracks. Under second track, these cases fall. And there it says 12 months. I don't know how it has come, but 21B says it is 6 months, but here it provides 12 months. Even within 12 months, we are unable to get a divorce petition getting disposed of in the trial court. So I am not telling anything against the system, court system. We are all part of it. We know that within growing number of cases, less number of judges, less number of courts, less number of, there is dearth for this infrastructure facilities, and we know what our country is. So we can't expect something to happen overnight. So how many cases can a family court handle? But when you say this divorce proceedings, I always say divorce proceedings have shelf life. For example, we buy any edible item, there will be a note on the pocket. It says best before 6 months, best before 12 months, like that. So if I move for a divorce today, and then my opponent says I want restitution of conjugal rights, and the matter is decided after 12 years or 10 years, is it of any value to an individual is one question. I also feel that this divorce decree is too personal to an individual. It runs with a person's age. After a certain point of time, what is it that you are getting? You are getting only subjective satisfaction or objective satisfaction of getting a decree of divorce, even if you succeed. But personally, what are you getting? Why did you go to court? At a given age, why did you approach the court? You approach the court in order to see to it that as per 21B, you get the relief so that you can take your life forward. Even if you do not get the degree, what has to be done? That's what you are looking at. But what is promised under the statute, at times we are unable to give to the litigant. This is one area where we have to seriously think. Now you see, as far as divorce proceedings are concerned, I always say it's a cluster. It's not just one divorce proceeding. Whenever there is a divorce proceeding initiated by one person, immediately we have restitution of conjugal rights, case for restitution of conjugal rights filed by the other spouse under Section 9. There is 498A. There is a DV Act. There is a petition filed under the DV Act. And there is a petition filed under JNWC if there are children. And even if it is a divorce proceeding or Section 9 proceeding, there is an application filed under Section 26 for custody of children. And there is Section 24 for pendental maintenance or interim maintenance. And there is Section 27 where the property presented at or about the time of marriage, how it's to be disposed of if it may, when it belongs to both the parties. And in addition to this, there are several complaints given by either of the parties against the other party to their employers, to embassies, to different passport and visa authorities, etc. So, though it looks like a divorce proceeding, it's a cluster. It has many other cases associated with it. Offshoots, we do not know. How the dimension and the dynamics of divorce proceedings is unimaginable. Where it will reach, nobody can even imagine. Let us go to a court scenario. What does the court consider? Court looks at cause of action. Somebody was telling me, cruelty, all those things, let us forget. What is the cause of action for the divorce? Marriage is the cause of action for the divorce. In fact, in most of the cases, we write the cause of action has arisen on such and such a date, which is the date, that is the date of marriage. But for the marriage, the divorce proceedings wouldn't have been there. That's one in a way. Courts look at the cause of action, the relief claimed, and then grounds for the relief. What are the grounds for the relief? Whether those grounds are proved or not. And then court will draw its own inference and pass a judgment as per law. This we need to understand very carefully. So, if you see this structure from cause of action to passing of the judgment, the scope of the court is very limited because if it is minus ADR, it has to work within the framework. Now, let us see some of the grounds under Section 13 of the Hindu Marriage Act. I'm not going to take you through all the grounds. 13.1 says, 13 Romanet 1, that is 13I you can say, but it is Romanet 1, small case 1. Voluntary sexual intercourse. If the other spouse has got voluntary sexual intercourse, then that's a ground. How can one prove voluntary sexual intercourse? That A had voluntary sexual intercourse with the other person. Maybe someone can prove. They come to us and say, Madam, he is in a relationship with somebody else. There is a voluntary sexual intercourse. Fair enough. But what is the proof that they give before the court? They can give before the court. This is one aspect. 13 Romanet 1A. treated the petitioner with cruelty. I'll come to this little later. Then 1B, 13 Romanet 1B. Desertion for a continuous period of 2 years preceding the petition. If you go through several judgments on this desertion, it says that you can't be a wrongdoer. Because of your wrongdoing, the other spouse must not have left the house. So even if you say my wife has gone out from me or my husband has moved out from me, it should not be because of you. That's one aspect. That also must be taken care of. And then, of course, conversion to another religion. There are some persons who have changed faith. It's personal, it is individualistic. But they have not disclosed it or made it public. How do you prove that a person has got himself converted into another religion? There again comes a proof. If you simply make a statement, based on your statement, courts may not be able to help you to get a decree of divorce. Then the most difficult part is a lady or a man suffers when the person is mentally ill. The other spouse is mentally ill. You have to take shelter under 13.3. If you go Romanet 3, it says the spouse must be of incurable, the spouse has been incurably of unsound mind. Supposing there are some behaviors of an individual which cannot be tolerated by the other spouse, and the other spouse is very sure, confident that there is some mental illness, then that cannot be a ground, because when he is taken to the court, the doctor may say it's a curable disease. There are 3 types. One is curable, one is controllable, one is consolable. Incurable falls under the consolable category. But the doctors will say, oh, no, if he takes the tablet or whatever we have prescribed, the medication, throughout his life, you can continue. Who will take this risk? Incurably of unsound mind and has been suffering continuously of continuously or intermittently from mental disorder of such kind and such extent that petitioner can't be reasonably expected to live with. Please consider these words. One is incurably of unsound mind. How do I get it? How do I take my husband to a doctor and get him certified that he is incurably of unsound mind? This is very difficult, my husband or my wife. And then he should be suffering from some illness which is continuous, which is not just intermittent here and there. This is also very difficult, and it should be of such kind and such extent. Who is going to decide what is such kind and such extent? One aspect, I'm afraid, I'm threatened, and I walk out of my husband's house or I walk out of my wife's house. But will the court take a call on one single action? Who will help me to get evidence that it is continuous? Who will help me to get that the disorder is of such a kind that it is difficult for me to live with him or her? That's where filing a case is different, but proving within the frame, bringing the case within the framework of law is a challenge even to any lawyer. See, explanation A and B are very, intelligently worded as far as this 13.3A and 13 Romanet 3 is concerned. B says psychopathic disorder. How do you prove a psychopathic disorder? It should be a persistent disorder. With the first action, I am out of the house. How do I show? What do I place before the court to show that it's a persistent disorder? Will my in-laws help me to get it certified that their son is having this disorder? Who will help me? Or will my parents help my husband in getting this? These are questions. Explanation A refers to schizophrenia. It's very difficult We have worked with several, counselors, several psychiatrists. It's very difficult to get a certificate from any doctor about schizophrenia. We all know this. Because sometimes they are absolutely normal, better than any one of us. But only at particular point of time, you can't handle them. But how do you give these proofs is one aspect. When we say these aspects about, these are the grounds that you have under section 30, you also see that 13(1) capital A is there. So it says, if there is no resumption of cohabitation between the spouses within a period of 1 year or upwards, after you have got decree of judicial separation. So some people intelligently agree or intelligently move to get a decree of divorce. Instead of decree of divorce, they try to get a decree for judicial separation and then say, post that decree for judicial separation, there has been no cohabitation between us for more than 1 year. So grant us a decree of divorce. But Supreme Court in 2001 for SEC 125, Hirachand's case, Hirachand versus Sunanda's case, Supreme Court clarified this. It clearly said, Section 10 Clause 2 does not vest the petitioner with right to get a decree of divorce. So even there you are out. Now you see 13(2). If you go to section 13(2) clause Romanet 1, if a spouse has got another person married to him or her, then you are entitled. This section has to be read with section 17. Section 17 says bigamy is punishable. But people say, madam, my husband is married to so-and-so. I'm still his wife. My petition for maintenance is pending. He has married to so-and-so. Or he will say she is married to somebody else. But how do you prove this? For this, you have to fall back on section 17. And you should fall back on several decisions of the apex court under section 494 of IPC. A 3 judges bench decision in case of Baurav Shankar. There it has said, you can't simply say my spouse has got married to somebody else. That marriage has to be a valid marriage. And what is a valid marriage? It should be a marriage under the Hindu Marriage Act. And it should be a marriage which is solemnized. When you come across, when you say it is solemnized, you have to fall back on section 5. If somebody asks me today, I'm 35-year-old, what is the proof? You have got to show that your marriage is solemnized as per Hindu law. Probably I have to, question myself, from where do I get the proof? The fact that we are living as husband and wife alone is not enough, is what the Supreme Court has said in some cases. This is a 3 judges bench judgment. So even there, 13(2) also may not be helpful. The only area where we can safely move, the lawyers can safely move or try to get some relief to the clients is probably under 13 Romanet IA, that is cruelty. But how do you prove cruelty is again a challenge. Probably it is Vinit Saxena's case. Yes, Vinit Saxena's case, AR 2006 Supreme Court 1662. Yes, Vinit Saxena, AR 2006 Supreme Court 1662. Supreme Court has said, as far as cruelty is concerned, you have to see both sides. 2 sides must be seen. If I allege cruelty, based on my allegation alone, court cannot give divorce. It should see both the sides. The entire matrimonial relationship must be considered. That's where single acts of cruelty will not be honored by the courts. There has to be threat to the person or threat to life. If you read several judgments on cruelty, cruelty is not defined anywhere. Of course, we have to fall back on judicial precedents. But what is cruelty from the perspective of a litigant may not be accepted as cruelty from the court side. A single act of cruelty and then it is condoned. Today my husband hits me. Tomorrow I sleep with him. And next year I give birth to a child. And then say on that day my husband hit me, grant me divorce. Court may say the subsequent actions, by your subsequent actions, you have condoned what according to you was conceived as cruelty. This may also happen. So we have to be very careful. And Naveen Kohli's case is one beautiful case which I request all the youngsters to read. In Naveen Kohli versus Neelu Kohli, AR 2006 SC 1675, Supreme Court said, court cannot import its own notions of life. Court cannot import its own notions of life. And look at several judgments. It's very interesting to see how there is evolution of law. And notwithstanding such a wonderful evolution of law, we are unable to say what exactly is cruelty is because there is no strict jacket formula. Sonali Somal versus Vikrant Parida. Vikrant Parida's case, Sonal versus Vikrant Parida's case is a judgment by the Orissa High Court. Notwithstanding it's by the High Court, they have considered the question of allegation of cruelty in short-lived marriages. Within 15 days, the wife comes out or the husband moves out. She is cruel, he is cruel. Nowadays, we are getting such cases only. But we say so many things while drafting. Yes, whatever the client has said, we have to say, we will say. But will the court consider in short-lived marriages? This is where we need the expertise also. Now you see, in Sarla Mudgal's case, AR 95 Supreme Court, 1531. Sarla Mudgal's case is one classic case where the court said, you can't travel beyond the grounds given under the statute, provided under the statute. You have to go strictly as per the statute. I read you how mental illness, in case of mental illness, how cruelty has to be considered, all these things. We can't travel also beyond what is provided under law. And there is one Hirachand's case, AR 2001 SC 1285. In Hirachand's case, Hirachand versus Sunanda. In that case, court said, you can't have general principles of universal application. It has to be considered on case-to-case basis. So when a client comes to us, we say, yes, we will take your case, you have ground that, this. But are we sure ourselves what will happen? Of course, ultimately we can assist our clients in putting forth her or his case to the court. We can channelize. But what will happen there, we will not be knowing. I'll take you through one strange case. This is a case reported in AR Bombay 2020 Part 1, page 431. It's a beautiful case. KGP versus PKP. Both the spouses are doctors. Wife's petition for restitution of conjugal rights and husband's petition for divorce. During the pendency of her proceedings before the court, her Section 9 petition before the court, she files a peculiar application before the court stating that, ask my husband to cooperate with me so that I give birth to another child, number one. If he doesn't agree, let us both go through artificial IVF process so that we get a child. What will happen ultimately is different. I am already 35-year-old. If we look at this case, I request all of you to kindly read this judgment. It's very interesting. This says with what amount of intelligence and thought behind it, Section 21B was introduced under the Hindu Marriage Act, providing that within 6 months, the matters have to be completed and within 3 months, the appeal has to be disposed of. But we are unable to get this. And even if we get it from one court to another court, the cases move from one building to another building. With that, our age also gets moved. I am 25 today, I will be 35, 40. And I will not have the capacity to get a child. Even if my case petition for restitution of conjugal rights gets decreed by the highest court, can I expect my spouse to come and live with me, have conjugal relationship with me? These are all larger questions. That's where we need to fall back upon ADR mechanisms. As far as this ADR mechanisms are concerned, if it is mediation or conciliation, all these ADR mechanisms help a party to help both the parties to resolve the dispute. It's a process where the parties to a dispute are facilitated by an expert and helped by an expert to resolve the dispute between the two of them. We have lots of time which courts may not have as ADR experts, be it mediation or conciliation. In mediation, generally in the Indian context, we don't give proposals. But there are some persons who want somebody else to take a call for them or decision for them. Then conciliation is the right choice. Conciliation also, you need not have to equate conciliation as far as the conciliator's role in Lok Adalas that we have seen. There are some conciliators who seriously work more or less the techniques that are adopted by mediators are being adopted there. An additional advantage is that a conciliator can also give proposals either orally or written proposals also can give to the parties. It is for the parties to agree or disagree. The basic thing that in ADR mechanisms we address is what does a party want to happen? What does not a party want to happen? Why does a party want to happen something and why does not a party want to happen? Many of the cases are filed at the spur of the moment. I always keep telling these matrimonial cases are filed because of temporary feelings claiming permanent reliefs. In many cases, after going through the mediation process, parties say the husband or the spouse who has moved the court for divorce, they confess, they tell, just to threaten the other party, I filed the divorce proceedings, madam, I don't want divorce. There are some cases. And when there is an empathetic connection that is brought between the parties and there is a joint session where parties are made to speak to each other, then they explain why they filed, why they did what they did. But I have seen with my limited experience, I'm telling, if the parties are dragged to police station, if the parties are put behind bars, the chances of reunion is very less. In Indian scenario, still people are unable to accept that police stations should not be viewed in a manner which is not to be viewed from the society's perspective. It's a place where we both can approach to get justice. At the threshold stage, we can approach, but that concept has not yet percolated into the mindset of our Indians. So as on this day, if the in-laws are brought before the police stations, probably the chances of reconciliation becomes very less. When parties approach court, they have so many things in their mind. The moment I have filed, the other person will come and fall to my feet. It may not happen. During the process of mediation or conciliation or whatever it is, or if it is referred to neutral evaluation, which is wonderful option, then some expert will tell the parties, even mediators cannot directly tell them the strengths and weaknesses of their case, party's case. But you have alleged so many things. How do you prove these things? Then they start questioning themselves. Filing a case is different. Conducting a case is different. Adducing evidence is different. Proving or supporting evidence to be given to prove the allegations are different. When a person is taken through these stages, then they will feel it is better to get the matter settled. The alternative dispute resolution mechanisms helps parties to understand the strengths and weaknesses of their cases. They have given, and even for the lawyers also, I see only my particular party's perspective. When I participate in mediation along with my client, I see what the other person has said. I see his perspective also. So both the views are placed there. And going by the judgment in Vinita Saxena's case, the whole matrimonial relationship must be considered. That's what the Supreme Court has said. So we can tell the party, look, as an advocate who plays a cooperative role in ADR mechanisms, I can tell the party, look, Vinita Saxena's case says like this. You have said this and I have filed the case, but your spouse says this. The court will have to consider the entire picture, entire scenario. That's where you stand. You take your call. See, notwithstanding the proceedings before the court, the reliefs claimed are different than relief actually expected by the parties. Just because husband has filed divorce, the wife may also file a petition under Section 9. But actually, she may tell you in confidence that I don't want to live with him. But only as a weapon against the other party, she wants to use this restriction of conjugal rights petition. Now you see, what are the things that can be negotiated? One is alimony, another is exchange of articles, visitation rights, workable solutions as far as visitation rights are concerned, and contributions made to the family. I am a working woman, I give everything for the family. I buy rice, I buy groceries, I buy this, I buy that. All my husband's earning is invested on the properties. At the end of the day, if we move for divorce, I am going penniless. But based on this, will court give any award to me? You are gainfully employed. I don't want to give you anything. Are lakhs and lakhs of rupees in my 10 years of marriage I have spent for the family. Courts may not agree to this. Then in mediation, we can bring sense to the other party also. Whatever they want to deny on paper, but in mediation or in conciliation, they may agree, yes, it's true that so-and-so has contributed so much. And as far as properties which are purchased in the joint names of the spouses, even in such cases, mediation is a better option. At times, what happens is, my husband might have bought a property in my name. The entire contribution may have flown from my husband's side, but there may not be any proof. Or my husband might have bought a property in his name. The contribution might have flown from me or my parents or somebody else. There may not be sufficient proof which I can place today. But these cases can be worked out as far as these formulas can be worked out as far as this, if we make use of ADR mechanisms is concerned. We should also know where mediation or conciliation in divorce proceedings will not work. I had a peculiar case where the husband wanted a divorce. He filed a petition. Wife denied everything, but she said, I also want a divorce because of ABC reasons. Husband said XYZ reasons, I want a divorce. Wife said, I also want a divorce because of ABC reasons. So both have asked for divorce. I thought the matter will get settled. But husband said, she has made allegations against me. Let her prove the allegations in the court. Until she proves the allegations against me, I am not going to give up. I don't want a divorce proceeding by mutual consent. I want a decree of divorce by an order of court where the court will hold that my wife has meted out cruelty to me. That's what I want. So where they are particular about getting a judicial decision, ADR mechanisms cannot work out. There are some cases where they give very valid reasons of cultural barriers. In our culture, nobody takes divorce. I had a case of my good friend, classmate, she is no more today. I really feel sorry. We had filed a petition, original suit for maintenance. Husband was he was in very reputed position. He was working in North India. On paper, we had several lakhs of maintenance awarded to her, accumulated maintenance. But we are unable to get the decree executed because never it used to get served upon him. And occasionally it would get served and then again he will go out. Precept, so many things, all order 21 we had by-hearted, but it was of no use. Then he filed a petition for divorce. We said you can agree and you can get alimony. I'm speaking of a situation 25 years ago when this mediation and other things were not there. Very wonderful lawyers from our Mofussil court, senior lawyers, they conciliated and they said, he is ready to give 4 lakhs, why don't you take? She said, no, in our caste, it is not permitted. They look down upon me, and then I don't want to agree on this. Now what happened? The husband died. Husband died and she wanted to move against his assets and other things. Incidentally, this, my friend, good friend of mine, she had terminal illness and she also died. What will happen? Her brothers are coming and asking, we had been taking care of our sister for the past 25 years when husband had abandoned. Can we get something from the assets of my brother-in-law? Look at these strange situations. Why this? Because of time. People have unrealistic imaginations. Oh, through court I will get so much. Why should I agree? If X says I will give so much towards alimony for buying peace, why may not agree? Because they have unrealistic expectation. Earlier, supposing I am wife of so-and-so today, if I get a divorce from tomorrow, I am not wife of so-and-so. So because of me being removed from that status of wife of so-and-so, the alimony factors were being considered. But today it's not so. Universally, alimony is given in respect of maintenance and nurturing and nourishment. So how much do you expect from court? It's only through ADR mechanisms one can expect good alimony. Otherwise, it's very difficult. And sometimes people feel status quo is better. Where people feel status quo is better, there also ADR mechanisms will not work. I will continue in the court. Let him also continue in the court. Let court not give divorce in his favor. Let court not give decree in my favor of restitution. Let us both continue in our lives till our death in the court. This is risk-bearing capacity of an individual. They want to live in status quo position. There also this will not happen. And another scenario where you, as a lawyer, we have to see, referring the cases to mediation several times, you will understand whether your client will agree for some settlement or not agree for settlement. If the client doesn't agree for settlement, you have to fall back on your research and your efforts to see how you can get her relief under the statute. Another scenario is something where they want to avoid precedent being laid down. In our family, no one has taken divorce. I'll be the first one to take divorce. So-and-so has taken divorce. So I don't want to go for this. This is another scenario. So just because we are integrating this ADR mechanisms into the court proceedings, it's not definite that all the cases, all the divorce proceedings will get resolved through mediation or conciliation or neutral evaluation itself. But by and large, 50 to 60% of the cases may get resolved at best or at worst, if not in the first mediation or conciliation process, on a subsequent date. With this, I would like to conclude and thank you all for your patient hearing. Thank you.
Thank you, ma'am. The different perspectives and the value of ADRs has beautifully been explained. Just checking.
A lot of appreciations are pouring in and the questions.
Yeah. I was just checking it out. One question is regarding admissibility, but that is not the topic. So I think it has been well received. And I just saw that Mr. JP Sen had logged in. If he is there, I will see his too. We can have his insights also. Mr. Sen. Was he had logged in? No. So thank you, ma'am, for sharing your knowledge. And we will share this session's YouTube amongst the group. And thank you, Vikram, for joining with us. It's always a pleasure connecting for the insights.
So much. Thank you, ma'am. And I see a lot of mediators from our Bangalore Mediation Center participating in our webinar. It's a very happy thing to know. I see Mr. Joseph, Mrs. Jayashree Sridhar, so many other mediators. Ma'am, once again, thank you so much for enlightening us and for sharing and enriching us more so with the citations. I would go through all these citations once again, so that would give us more insight as to what is the position of law. Though we get divorce time and again, but the law is something very complex that the courts have mentioned, as you were trying to mention a few minutes ago. It would be better if we resort to this ADR mechanism. Of course, there are constraints. Thank you once again, ma'am.
I shared prior to the session also, today also, we had settled a case wherein around 10 cases have settled. So ADR is proving to be a very effective tool. Thank you, everyone. Stay safe, stay blessed. Namaskar. Good night.
Thank you.